Hello, good evening. Welcome to Starr today here on Starr FM. I am Tutuwa Dan. So let's take a listen to the stories making the headlines in this broadcast. And coming up, huge relief for Ghanaian taxpayers as Parliament scraps e-levy, betting tax and emissions levy. We'll hear from an elated finance minister on how these reliefs will impact the ordinary Ghanaian.
We have saved it. That is savings. That is savings. That is the definition of savings. And so, for me to put it in proper context, for you to understand, that is savings. So if you don't understand that is savings, it's up to you. But we have made savings. Going forward, we will not use the taxpayers' money for these purposes. Simple.
We will take you live to the floor of Parliament shortly, where MPs are considering estimates for the various ministries, departments and agencies. Also coming up, Council of States begins deliberations on fate of Chief Justice Gertrude Tokonu as 3 petitions demanding her removal refer to them. Stay with us tonight as we break down what could possibly happen, including the possible appointment of an acting Chief Justice in the coming days. And later in this bulletin, we bring you experts' insights into whether detaining the former Director General of the National Signals Bureau, Kwabena Duboahen, and his wife, Angela Boateng, beyond 48 hours constitutes a human rights violation.
Can you imagine that? People have not been charged. People who have not been brought before a court of competent jurisdiction should plead bargain. What is worse is the hard fact that they've not even taken the statements of the suspects, my clients.
Also in this belt, Chamber for Local Governance commenced President Mahama's bold move to nominating 72 new MMDCs in 8 regions. We have the details of these and many other stories making up this 90 minutes broadcast. Do stay.
Starr News is coming to you live on Ultimate 106.9 FM in Kumasi, Empire 102.7 FM in Takoradi, Cool 103.5 FM in Ho, Rage and Might FM in Tamale, Somali FM in Wa, My Star Radio in the USA. Also live on Facebook on Starr 103.5 FM and on starfm.com.gh around the world. This is Starr 103.5 FM.
Thank you very much for your time this evening on the bulletin. I am Tutuwa Danso, and this bulletin is streaming live on Starr FM. That is on the Facebook page at Starr 103.5 FM. Now, the ordinary Ghanaian can heave a huge sigh of relief after Parliament amended and repealed some laws to do away with a number of taxes. The consuming public will not be paying e-levy, betting tax, among others. The governing NDC, while in opposition, promised to abolish these taxes, which they described as unconventional. Now, speaking during the passage of the bills to scrap the taxes, Finance Minister Dr. Kaseo Asafosun argued the move is to bring relief to Ghanaians who had been overburdened.
Another important point that must be made is that
the tax refund account money for. So, Speaker, by failing to spend, and the Speaker, most importantly, by sticking to the law alone, what you have done is that you have saved the taxpayer some money. So, Mr. Speaker, I don't understand what the former Minister of Finance is trying to say. Mr. Speaker, definition of savings, savings is savings. We do not have different definitions for savings. If in the past, monies that were supposed to be used for tax refund purposes was, for some reason, used to pay for certain contractors, and another government decide not to use the money to pay a particular contractor, and you don't call this savings, then what it is? So, Speaker, what it is? The difference is that we have decided as a government not to spend the money on things that has not been appropriated. We have decided to spend the money for the purposes of tax refund. And so, Mr. Speaker, we have made money available, additional money available for appropriations. And so, if he doesn't understand that this is savings, Mr. Speaker, I don't know the definition of savings. Mr. Speaker, we have made savings from abuse. We have stopped the bleeding. That's what we have done. And that is savings. And if you want us to go on that road, we'll go on that road to define what savings are. Mr. Speaker, in the past, some of these resources was used to pay for services that we do not have contract for. For services that we do not have contract for. Going forward, we are saying we are not spending on that. And so going forward, that expenditure that we have cancelled, we have saved it. That is savings. That is savings. That is the definition of savings. And so for me to put it in proper context, for you to understand, that is savings. So if you don't understand that is savings, it's up to you. But we have made savings. Going forward, we will not use the taxpayers' money for these purposes. Simple.
You just heard from the Finance Minister, Dr. Cassiel Ataforsen. Now, on his part, the immediate past Finance Minister, Dr. Mohammed Amin Adam, had issues with claims by government officials that the decision to reduce the rate of the tax refund account from 6 to 4% amounts to savings.
Under fiscal impact analysis of the bill, the minister indicated to the committee, as captured by this report, that between 43 to 49% is usually spent. And according to the Revenue Administration Act, Section 63, subsection 3, what is not spent at the end of the calendar year should be moved to the consolidated fund. And so if based on that, the minister has reduced the percentage of what should constitute the tax refund from 6 to 4%, the 2%, which is resulting into what the minister calls savings, is already supposed to go to the consolidated fund. It's already part of government revenue. The only thing the minister has decided to do is to front load the utilization of the 3.8 billion. If he did not decide to front load it, it would have gone into the consolidated fund. And this is a saving as a result of the new policy, and therefore suggesting that something great has happened, because of this policy. Mr. Speaker, I beg to differ, and I thank you for the opportunity to contribute.
Mohammed Amin Adam is the former finance minister, but the former finance minister and his deputies, however, insisted it amounts to savings.
Look, Mr. Speaker, another important point that must be made is that some suggested that the law is clear, that it is up to 6%, a ceiling of 6%. So we don't necessarily have to transfer 6%. Administratively, we could have decided to do less. But the finance minister wants to be disciplined and resist the temptation of doing what is wrong. And that is why this is being brought here for all of us to set the ceiling at 4%, which is consistent with the amount that has been utilized over the years.
We have decided to spend the money for the purposes of tax refund. And so, Mr. Speaker, we have made money available, additional money available for appropriations. And so, if he doesn't understand that this is savings, Mr. Speaker, I don't know the definition of savings. Mr. Speaker, we have made savings from abuse. We have stopped the bleeding. That's what we have done. And that is savings. And if you want us to go on that road, we'll go on that road to define what savings are. Mr. Speaker, in the past, some of these resources was used to pay for services that we do not have contract for. For services that we do not have contract for. Going forward, we are saying we are not spending on that. And so going forward, that expenditure that we have cancelled, we have saved it. That is savings. That is savings. That is the definition of savings. And so for me to put it in proper context, for you to understand, that is savings. So if you don't understand that is savings, it's up to you. But we have made savings. Going forward, we will not use the taxpayers' money for these purposes. Simple.
Well, those were excerpts of what happened on the floor of Parliament. But let's take you live to Parliament. And joining us over the phone lines is our parliamentary affairs correspondent and also the head of the political desk here at EIB Network, Ibrahim Al-Hassan. Thank you very much for your time, IB. I mean, how did the discussion pan out on the floor of Parliament? Hello, IB.
Hello, Tidua.
Fantastic. Thank you very much for joining us. I just want to find out from you briefly, how did the discussion pan out on the floor of Parliament?
Well, so a number of tax bills have been attended to, as you've already mentioned to listeners. And so e-levy is gone on paper, not effective as of yet, and I'll explain this later. Betting tax is gone. In fact, and there was something interesting that happened relative to the betting tax. The finance minister had mentioned that the NDC in opposition promised to scrap the betting tax. Now, there were two other components together with the betting tax, and that have now been added. One is the winning on gaming, so any form of gaming whatsoever. If you win per the act that was existing, you were expected to pay something by way of taxation. Again, lotteries, that was never implemented, and that is the one being administered by the National Lotteries Authority, NLA. That has equally been abolished, even though it was never implemented. So, according to the finance minister, even though the NDC in its manifesto promised to abolish just the betting tax, which is just one component, they've added two more, making it free. So, be it gaming, be it lotteries, be it betting, all the taxes have been abolished. So that's one. The other one has equally got to do with e-levy, as I mentioned. The reason why I mentioned that these abolishments are on paper as of today is that, Vanessa, if you send any money as we speak through your mobile money wallet, you pay e-levy. That's because even though the bill has been repealed, or the act has been repealed through the passage of another bill of repeal, the president will have to sign it into law. Once the president signs it into law, that will be the point where it becomes effective. And for that matter, we can say that indeed e-levy has been abolished, not just on paper, but also indeed. And that's expected to happen sometime next week. Mind you, Monday is a holiday, Tuesday is a holiday. So if we are to hear any news about presidential assent, it will be from Wednesday to Friday next week. So, yes, those amendments have been taken, and as we speak, the House went on a 30-minute suspension to return and not just attend to the other outstanding financial bills. In fact, there were 21 of them. As at the time the House was going on suspension, just about 4 of them had been attended to. There were still some more outstanding, after which the budget estimate for some ministries, departments, and agencies will equally be tabled tonight. So the House is undertaking what we call a extended sitting, meaning that MPs will have to sit late in the night to attend to these businesses, among others.
I mean, this must be fantastic news for Ghanaians, but did we see any spirited opposition from the minority side of the House?
No, that would have been suicidal, because the minority itself, when it was the majority and the MPP was in power, had promised to scrap or abolish these same tax lines, from e-levy to COVID levy to betting tax and what have you. And so there was no opposition whatsoever. In fact, if there was anything at all that came from the minority leader, it was an encouragement that the NDC has been able to abolish these taxes. It could do more, and that it should go ahead and do more, and that when Akufo-Addo promised to abolish some taxes, on his count, the NPP administration then abolished 15. So there's nothing new the NDC is doing. In fact, the NPP minority will encourage NDC to go ahead and abolish more taxes. Alexander Kwame Afenyomarkin speaking.
I see, but how many estimates as we speak have been approved for the ministries, departments and agencies?
So Energy Ministry and Green Transitions, home and dry, roads and highways, home and dry, and a few others. In fact, overwhelming majority of ministries, departments, and agencies have not had their budget estimates attended to. Yesterday, as at the time that we were living, just these three that I mentioned had their estimates attended to.
Right. Ivy, thank you very much for speaking to us. That is our legal parliamentary affairs correspondent, also the head of the ERB political desk here, Ibrahim Al-Hassan. But let's still stay in parliament this evening because the minority leader, Alexander Kwame Penyumarkin, has questioned the fanfare surrounding the scrapping of the taxes, arguing that the Nado administration scrapped as many as 15 taxes in 2017. Now, the Futu MP encouraged the NDC to scrap more taxes.
Now we hear our friends praising themselves, claiming that they are fulfilling their campaign promises, their selective fulfillment of promises. But I need to remind them that what they are attempting to do is not new to this House. In 2017, when the Akufo-Addo government presented its first budget, there were a lot of taxes that were repealed. And for the records, as many as 15 taxes and levies that were in place and had been in place through an enactment by the previous Mahama administration had to be repealed. So if today they are here with some fewer amendment to our tax laws, well, we would want to encourage them to do more. We are aware that in their time, Kayaye was even taxed. We are aware. Agro inputs, including the tools that the farmers use, cutlasses being used by the farmers in Boko, were taxed. Hoes were taxed. Import duties on spare parts were very burdensome. Mr. Speaker, if today they claim they are abolishing some taxes, well, to the extent that it's going to benefit the ordinary Ghanaian, we support it.
Alexander Penyumarkin is the minority leader, but the majority leader, Mahama Yariga, on his part argued the scrapping of the e-levy alone has put 2 billion cedis in the pockets of Ghanaians annually, thereby increasing their disposable income. The Boko Central MP added some Ghanaians could even use the savings to marry.
Removal will allow the Ghana Gold Board
and also the abolishing the emission tax levy. All of us who have been paying money in respect of e-levy, today we are taking that away by approving the legislation. So Speaker, now we are also making such facilities available to small-scale miners by abolishing the withholding tax. So Speaker, we continue to implement our promises to ordinary Ghanaians. Mr. Speaker, with those few words, and I believe colleagues support the second reading of the income tax amendment bill. Thank you, Mr. Speaker.
Yes, Honorable Minority Leader.
This is still Starr today here on Starr FM. We'll be back with conversations on this developing story after this break.
Starr today, first, fast, and credible.
Are you a LEAP beneficiary household member? Do you know a LEAP beneficiary in your community? For your information, the Ministry of Gender, Children and Social Protection will commence the nationwide joint payment of cash grants to beneficiary households of the LEAP program for the 94th and 95th cycles on 24th March 2025. Due to the joint payment, one eligible member household is entitled to 512 Ghana cedis, two eligible member households are entitled to 608 Ghana cedis, three eligible member households are entitled to 704 Ghana cedis, four more eligible member households are entitled to 848 Ghana cedis. Count your money before leaving the pay point or bank, or ask your community volunteer or social welfare officer to assist. Do not accept any amount less than expected. Demand your receipt after being paid and keep it for reference. Caregiver, do not give part of your money to anyone for any reason. Caregiver, spend your money on your household's nutrition, education of children, and invest in productive activities to earn income and assets for sustainable livelihoods. This is important because all beneficiary households will not be on the LEAP program forever. Report challenges about the program to the community focal person or district social welfare officer. Also, you can call these toll-free numbers 0800 800 800 or 0800 900 900. Again, the 94th and 95th cycles joint payment will commence on 24th March 2025. This message is from the Ministry of Gender, Children and Social Protection and the LEAP Management Secretariat.
Starr Today. First, fast, and credible.
Are you welcome back from that break? This is still Starr Today here on Starr FM. I am Tutua Dance. We tried working the phone lines to have a conversation with some stakeholders of this scrapping of the taxes, but unfortunately, all calls have gone unanswered. As and when we do get a conversation, we'll bring it to you. But away from that, Ghana's legal system, including the Chief Justice, is currently on tenterhooks as the Council of State begins deliberation to decide the fate of Chief Justice Gertrude Tokonu. A statement from the presidency's communication directors on Tuesday, March 25, 2025, confirmed that President John Dramani Mahama had forwarded 3 petitions seeking the removal of the CJ to the Council of State for advice. Here is a news desk report of reactions in the last 24 hours.
Not her first time in this situation. In a space of 3 months, Chief Justice Gertrude Araba Isaba Saki Tokonu once again has her fate in the balance following 3 petitions to the president for her removal. In December 2024, legal scholar Professor Kweku Asare, in a 19-page petition, asked for her removal over alleged misbehavior and incompetence. Then President Akufo-Addo, on 6th January, in consultation with the Council of State, dismissed the petition, concluding it did not disclose a prima facie case warranting further action. The then presidency also indicated the petition was submitted without supporting evidence or documentation to substantiate its claims, further expressing disapproval that the petition was circulated in the public domain in breach of Article 146 of the Constitution, which mandates that proceedings of this nature be held in camera to protect the integrity of the judiciary. President Akufo-Addo in 2021 had dismissed a similar petition from ASEPA to remove Chief Justice Enini Obua. But in what could be described as a déjà vu, the Chief Justice again awaits a determination of her fate, howbeit under a newly constituted Council of State and a different precedent. Although details of the petitions and petitioners remain sketchy, former director of the Ghana School of Law, Kweku Asare, says the Chief Justice is the architect of her own problems.
It raises a question of interpretation, so that even if there's no issue of interpretation, you raise one for yourself and decide. When you do that, you bring problems. And Tokonu has brought all these ugly noises about her by herself. And you've been a kumanki. She has stabbed herself wrongly in the foot.
He, however, urged the Council of State to review the petitions dispassionately and cautioned against interference by the president.
It is a body very distinguished, very capable. Let us allow them. Let us allow them. Don't let the president attempt to interfere, to dictate how their mind should go or where their mind should go.
However, private legal practitioner Wayo Ganamanti believes the petition is politically motivated.
it's all political, and the two political parties, both of them, when they are on each side, this is how they play. I have always felt that we should allow the judiciary to choose their leaders. They are judges, they are lawyers. We can go for a conference with the judicial staff. They will choose whoever becomes Chief Justice. I mean, if there are 5-6 people who are competent to be Chief Justice, just like Parliament. Parliament chooses its own Speaker of Parliament. It's the MPs who choose their Speaker of Parliament. So why can't the Constitution be amended for the judiciary to choose their own Chief Justice?
Amidst all these, the Council of State has begun its deliberations and is expected to proceed and operate in accordance with Article 146 of the Constitution.
That was a news desk report on the petition to remove the CJ from office. But I have in the studio with me this evening EIB's legal affairs correspondent Murtala Inusa, as well as our presidential correspondent Abdul Hanan Adam and Edem Kojo from our research desk. Gentlemen, good evening. Welcome.
Good evening.
Okay, I like that blanket response. But let's start with you, Hanan. I mean, we know about petitions that have triggered this move. What more do we know about it?
Well, like the lawyer said, Ganamante, people believe that this is politically motivated. But even though as presidential correspondents, we sought to find out from the government spokesperson, Felix Kwatiofosu, the people behind this. But according to the law, they are not supposed to give out the details of people who have petitioned the president for the removal of the CJ. Unlike what we saw in the previous administration, towards the tail end of the previous administration, the petitioner himself published the petition that he sent to then President Nana Addo Dankwa Akufo-Addo.
Are we talking about Kweku Azar?
Yes, exactly.
Okay.
So he decided to publish it, but it was not the government who or which authorized the publication of that document. And so the president is expected or has already given the green light to the Council of State to sit on the matter. So I believe that Murtala will take us through the processes. But currently, people, not only the media, including civil society organizations, are speculating reasons why she is being asked to step aside by some 3 people who have petitioned the president. And one of the reasons that are being speculated has to do with the issue of stated misdemeanor.
Okay.
Another one has to do with incompetence. That we cannot authoritatively confirm that is the reason, but these are just speculations that we are picking up.
That are contained in the petitions of the petitioners.
In the petitioners. But in the coming days, I believe that we'll have the full facts and be able to make. But for now, these are, the brief facts that we have about the reason why some 3 persons or individuals want the Chief Justice, to step aside. Another reason, which we discussed, has to do with when she suggested or she sought to nominate some individuals who the opposition then and other civil society organizations described as politically exposed persons to the court. Within that time frame, it was towards elections. That was around November. And the minority then, now majority in parliament, also kick against it. And so people are reading meanings into some of these things. And others also believe that, like I said, politically motivated, once there's a new government, then there's a need for a new chief of staff, like we saw the president do when he appointed a new IGP, he appointed a new CDS, amongst others. So people are reading meanings into that, saying that it is politically motivated. But others also would argue that if the petition, but because it has to do with law, which Murtala would explain, the president will not take his decision outright.
Right.
He would have to go through the processes to ensure that that is stated in the Constitution, not merely going through it, but would also ensure that it is satisfied, it is reasonable, it has to be in reason before the president will say, okay, Madam Tokono or Justice Tokono should take a leave of us.
Okay. I think I can now bring in our legal affairs correspondent, Murtala Inusa. Murtala, before we go through the processes involved in the removal of the CJ, when was the last time you saw her? And how has the judiciary been receiving this news? I mean, you were in court today.
Well, Vanessa, as you mentioned, in fact, this issue has been in the system for a while when Professor Starr, in fact, came up with a petition to have the CJ removed at the time. It was looked at like by the former president Nana Addo Dankwa. In fact, it was one of the last decisions that he took before leaving office. And one of the reasons that particular petition was dismissed because of how it was made public to cause public affection in relation to what is happening within the judiciary and all of that. You asked me a question about when was the last time I saw the Chief Justice in relation to all of that. This communique came out yesterday, the information came out yesterday night, that the president has referred petitions, in fact 3 petitions, to the Council of State to look at. And in fact, that is how it's supposed to be done. Today being Wednesday, today is Wednesday, March 26th, the Chief Justice, in fact, sat at the Supreme Court. He was involved in the cases that came up in the Supreme Court today.
Oh, she was in court?
Yes,
okay.
She was in court, very composed in relation to all that is handling.
She didn't seem bothered.
Absolutely. You will not see that from the body language. In fact, she chaired a panel even before the case that we were at the Supreme Court to follow came up. So in relation to all the things that are happening, if you ask me about when the last time I saw the Chief Justice Gertrude Sakitokonu, today she presided over one of the cases that came up at the Supreme Court, very well composed.
Okay.
That you will see her conduct cases or conduct affairs at the Supreme Court. It was the same body language that we saw today in relation to how, when this petition came up and whether she'll be involved in cases and all that nature.
Okay. I'll bring in Edem Kojo shortly, or we can actually do you now. I mean, Edem, what do we know about the previous attempts to have the CJ removed?
Okay, so I think that's one thing that people have not paid close attention to.
The attempts to have it removed?
Yes,
okay.
So in the last 6-7 years, this would be the 4th attempt to remove a Chief Justice of the Republic of Ghana.
Okay.
In fact, a Council of State member who is currently a former CJ by name Sofa Ekufu actually had a petition filed for her removal in 2018 by ASEPA. That's I think Mensa Thompson's firm. And ASEPA, which is the Alliance for Social Equity and Public Accountability, was then saying that the conduct of the sitting Chief Justice shows she's incompetent in managing the highest office of the judiciary, which has a constitutional mandate to be fair, just, and equitable in the application of laws of Ghana. So basically, they went to court they presented a petition to the president in 2018 asking for the CJ, and in fact, it wasn't just her then, it was also asking for the AG, that was then Gloria Akufu, and her deputy, Godfrey Dame, to be removed from office. However, the president just ignored the petition, and we never really had a formal response of that petition. So that's what we know for the 2018 petition. Now,
so that was the first attempt within the last 6 years.
The last 7 years, we'll say yes.
Okay.
Now, in 2021, that's July 13th, there was another attempt. By then, Sofa Ekufu had finished her tenure as Chief Justice, and a new Chief Justice was on the block by name Justice Eni Yeboah. Now, in 2021, the same ASEPA, Alliance for Social Equity and Public Accountability, filed a petition to remove the Chief Justice over his alleged involvement in a $5 million bribery case. I'm sure if there was time, Mutala can even tell us how this issue is actually one that is pending before the General Legal Counsel, because some other party has been taken to court for causing some issues to the Chief Justice. So this is actually a big issue in the General Legal Counsel. However, when it went to the president on August 21, in a statement, dismissed that petition and says it was upon the recommendation of the Council of States and that it was devoid of any basis. In fact, they said the petition was unmeritorious and unwarranted and devoid of any basis to remove the Chief Justice.
Okay.
So that was the second attempt in 2020.
And that was the reason the president gave?
That was the president's justification.
Okay.
Now, then recently, last year, December 2024, we had Professor Stephen Kweku Azar, who petitioned President Nana Addo Dankwa, and as Hanan said, on the allegations of misconduct and incompetence. Now, on the 6th of January, which was the day before the president's tenure officially, or the former president, Nana Addo Dankwa-Akufo-Addo's tenure, officially ended, the president, through his communication directorate, put out a long letter that dismissed Prof. Steve Azer's petition. It says that the petition lacked a prima facie evidence to constitute the removal of the Chief Justice. He also went on to say that so many allegations were made, but no evidence was adduced or added to the petition. The president also had an issue with the way the petition became public, as the president then said it was in violation of Article 1468 of the 1992 Constitution. So this that we are seeing is the fourth in the last 8 years to 2 hours.
Okay. Before we cross over to Mutala for a breakdown, former Chief Justice Sophia Ekufu has opted not to comment on the petition seeking the removal of Chief Justice Gertrude Tokonu, citing her recent swearing in as a member of the Council of State and her unfamiliarity with the petition and its response. She's granted his interview earlier during his swearing in. Let's take a listen to her.
That has nothing to do with the Council of State at this stage. It has not reached the Council of State. I'm not going to prejudge anything. I have not seen what I've seen of the petition is what I saw in the newspaper. I have not seen the Chief Justice's response. And no, I will not do that. I will not do that. I'm not her boss. I'm not the one. Yes, as far as I'm concerned, she's a judge performing her judicial function, and she's a Chief Justice performing her administrative function. There might be some reforms. The methodology for the appointment and selection of the selection and appointment of judges to the superior courts, that needs to change. I have already spoken about it many times, and I still stand by that because in the 21st century, we need a more transparent method of selecting people to assure that it is always by merit.
That was the former Chief Justice Sophia Ekufu speaking to my colleague, the presidential correspondent, Hanan Abdul Adam, during the swearing-in as a Council of States member. But let me come to Mutala Inusa now. Mutala, run us through what exactly Article 146 says, especially about the removal of the Chief Justice.
So clearly, removing a person like the Chief Justice is not just straightforward. It's not a straightforward thing that you can just go ahead and issue a statement and say that you have been relieved of your job effective immediately. It is Article 146 of the 1992 Constitution states processes or ways by which a person like the Chief Justice and somebody occupying the office, the position of the Chief Justice, can be removed. So the removal of the Chief Justice is governed by Article 146 of the 1992 Constitution, which stipulates that a Chief Justice or a Justice of the Superior Court can only be removed for stated, and listen to the reason. The really reasons that somebody like the Chief Justice can be removed: it one, stated misbehavior; number two, showing of incompetence; and number three, incapacity due to infirmity. And for those who had the opportunity to look at Professor Kuku Azar's petition that he came out with, he took time to give us some instances. One, he mentioned how the case of Upuni was treated. He mentioned how the Chief Justice, as it were, recommended that certain justices be upgraded or be elevated to the Supreme Court when the Council of State, it has to go through a process like the Council of State might have to look at it and all of that by way of the CJ justifying why the Supreme Court, justices of the Supreme Court should be increased to about 20 and all of that. So these were certain elements that the petition that we saw earlier came out, and kind of explanations that he gave to it. The other point that Article 146 also talk about is the effect that the law requires that when such a petition is received, the president must act in consultation with the Council of State to appoint a committee to investigate this allegation. And like it stated, yes, a committee, when the president received it, he must look at it, consult the Council of State. And then when they realize that there's something that have to be, a prima facie ought to be established. And let me just put this one on record. As we speak, the CJ has been notified, and I'm saying this one for the first time, the CJ has been notified of this, the existence of this petition. She has been written to as it were, come out with, to offer his explanation or her explanation, or to explain, or to give her own comments about the allegations that have been made, for which reason the president has referred the matter to the Council of State. As we speak, the CJ has been given that, has been notified of the petition, and her response has been elicited. Whether it is not clear is whether she has returned that to the presidency, by which this whole matter hovers around. And that is not all. When the committee is given the mandate to investigate these allegations, in fact, the committee must include 2 justices of the Supreme Court. So the committee should include 2 justices of the Supreme Court, one of whom automatically will serve as the chairperson or the chairman of the committee, as well as 3 individuals. And these 3 individuals are not supposed to be members of parliament. They shouldn't come from parliament. They shouldn't come from Council of State. They shouldn't be in the legal profession. So persons within the community who have, in fact, some are sound and can also come on and make a decision. So 3 persons.
In legal terms, you'd call them jury.
Absolutely. So they will come and assist the committee in coming to a determination of this sort. And if the petition is referred to a committee, as I've mentioned, the president may have to. So it's a discretionary remedy here. The president will have to decide whether to suspend the Chief Justice or to ask the Chief Justice to step aside until further determination of this case. We have seen this happen in so many situations where investigations are being carried out. The person at the center of the whole matter will be asked to step aside, just so they will tell so that you do not interfere with investigations and all of that. So that would have to be done. And of course, the hearing will be conducted in chambers. It will not be a public hearing. It will be done in chambers and all of that. And when the president officially asks the committee to do its work and all of that, refer the matter to the Council of State and all of that, whatever the outcome may be, the Supreme Court, the recommendations and the findings of the committee will be what will be adopted by the president. So if the committee is done with its work and makes the recommendation that we have looked at the petitions that have come and we think that no prima facie exists, there's nothing really to show that the CJ has demonstrated incompetence. The CJ has shown situations whereby stated misbehavior and also, of course, incapacity, unable to discharge her duty as it is, then the recommendation will come. But if it finds that there's nothing that warrants that further action be taken, then the president will have to allow the Chief Justice to continue with her work. So in this particular situation where the president has referred the matter to the Council of State, the Council of State will have to look at it. A committee will be constituted to investigate whether there is merits and these petitions that have been received or not.
Okay, but as Adam said, within the last 6 or 7 years, we've had about 4 petitions. Are we likely going to see a new acting CJ?
So the very last
are there some names that have come up?
With the last petition that we saw, immediately it came in, the president looked at it and dismissed. But what is likely to happen if the president, the committee is set up and the president takes the view upon consultation with the Council of State that, look, where it has gotten to, for the matter to be thoroughly or to be investigated properly, it will require that the Chief Justice steps aside. And that happened, it means there will be an acting CJ. And if you look at how the Supreme Court, the law that governs how Supreme Court justices will work, the most senior at the bench will be the one who acts until a substantive Chief Justice or until such time that investigations are done and the committee conclude its work and finds that this is the recommendation that we have made. The president will have a decision to make. So if the president decides that upon consultation with the Council of State that the Chief Justice should be suspended or should be allowed to step aside, definitely the senior most at the bench, at the Supreme Court bench currently, is Justice Paul Bafo-Boni, is the one that will be acting as the Chief Justice.
Okay. Mutala, thank you very much. That's the head of our legal affairs here at EIB Network, Mutala Inusa. But before that, the New Patriotic Party has also been speaking, and they have dared the Attorney General and the Minister of Justice, Dr. Dominic Ayine, to seek legal redress against former appointees accused of corruption and than seeking public sympathy from the media. Here is Director of Communications of the New Patriotic Party, Richard Ahiagba, addressing the media a while ago.
This is an irregular act. This is not how the fight against corruption has been carried on as far as this Fourth Republic is concerned. Many of you are aware that the Akufo-Addo Bawumia administration prosecuted some of the NDC people and jailed them. But those actions leading to their persecution and holding them accountable was not a media activity. This is one of the key things we think that we need to bring to your attention, because it is a deliberate act that a government is undertaking because it feels that perhaps it didn't have enough evidence, or the evidence it has against these individuals that it claim have conducted acts of corruption, that either the evidence they know cannot stand the test of scrutiny in the courtroom, or they simply are engaged in a political persecution to vilify individuals and create disaffection for the New Patriotic Party. And so the question we ask, ladies and gentlemen, is why the Attorney General is not going to court, but rather going to the media.
That was the Director of Communications for the New Patriotic Party, Richard Ahiagba. But let's go over the phone lines now. Still on the CJ developments, and engaged the Member of Parliament for Swami, and also a legal counsel on the minority bench, John Darko. Thank you very much, sir, for your time this evening. What will be your immediate reaction to this move to remove the CJ? Hello, sir. Good evening.
Good evening.
Fantastic. If you can hear me, I was asking, what will be your initial reaction to this move that seeks to remove the CJ?
Well, it's a political move orchestrated by the NDC, led by its leader, the president. We all know that when they were campaigning, they had made it a case that they were going to purge the judiciary, starting from the Chief Justice. In their view, anytime they lost the case, it was as a result of a biased CJ. Of course, it was far from the truth, and so they had this plan long ago before they assumed power. And so for some of us, it is not surprising. It is the attempt to erode the gains we have made in democratic journey. It is an attempt to bastardize our judiciary, starting from the Supreme Court. It is a political attempt which must never be allowed to stand. And so, if you ask me, that would be my initial reaction. This attempt by the government should not be countenanced by any well-meaning Ghanaian who loves democracy.
Okay, now if we pay attention to what is stated in Article 146, it talks about the conditions for the removal of the CJ, with one of them being a stated misbehavior, 2, incompetence to perform the functions of office, and 3, incapacity that is arising from infirmity of the body or mind. And these petitioners that we have, or these petitions we have seen in the last 6 years or so, have all pointed to the fact that she misbehaved in one way or the other. What's your reaction to that?
Who misbehaved one way or the other? This CJ?
The CJ, yes. Get you Tokono.
That's very interesting. I mean, I think it's so insulting to claim that a certain Chief Justice has misbehaved. I mean, what is the definition of misbehavior? If that's how we're going to go, it means that we want to throw our institutions under the bus, because at any point in time, somebody will just accuse a certain CJ of a misbehavior. Look,
okay, I mean, please hold on for me. Don't you think that we should leave this? Don't you think that we should leave this decision for the committee to determine?
It shouldn't have even started in the first place. But you see, it's just interesting. Why should the president even entertain this in the first place? Now I have also seen a petition. Somebody has written a petition against Chief Supreme Court Justice Gabriel Proman. We want to see what the president will do about it. Because somebody has also written a petition against it. And if we're going to allow this, then every day somebody will write a petition against somebody and list some grounds in the view of that person to claim that it's a stated misbehavior, and so for that matter, the person should be investigated. I think that if you look at it, we are just destroying our country. The framers of the Constitution wanted a situation where such a petition will be presented to the Council of State with the understanding that the Council of State was going to be apolitical. But what do we see? The Council of State has become an extension of the government as we see. Look at the people who are appointed, all former NDC officials. And during the election, you see what happened in Kumasi. They had to fight, ballot boxes had to be stolen, and they had to reorganize because of the serious political interest in the election of the elected portion of the Council of State. So clearly, it has become a political appendix. And so what they are going to do is to just more or less do what the president wishes. The president wants the CJ to be removed. So yeah, the Council of State will also do that. And then they will set up a committee which will be appointed by the president, and then they will bring a recommendation to the extent that the CJ should be removed and the CJ will be removed. Look, we are just destroying our country.
Okay.
I think that as Ghanaians, we should condemn this. There should be no ifs and buts in this. All of us should condemn this in no uncertain terms.
Let's talk about the composition of the committee. We have two acting chief justices, I beg your pardon, justice of the Supreme Court, and also 3 other members. From where you sit as a legal person, do you think that they'll be able to discharge their duties fairly?
Well, I see, as a lawyer, I always expect our courts and persons from the judiciary to act impartially, look at the facts and the law. That's all they have to do. But I'm just worried because of the politicization of our Council of State. And for me, that's my worry, that people will be so politicized, in their views, that they will not look at the law and the facts. They will only look at the politics, and that is not going to help any of us.
I want you to hold on for me for a minute, because we have in the studios with me the Deputy Director of Operations at the Presidency, Mustafa Gbandi. I mean, you have been here, Mustafa.
Yeah.
Thank you very much for coming, by the way. You've listened to George Dako. He says that we are just simply destroying our country if we go on this tangent. What is your response to that?
I think I'm quite disappointed. If this was coming from an ordinary politician, it would make some sense to me. This is coming from a lawyer. My brother is somebody I admire. Unfortunately, after becoming an MP, he has thrown the law to the dogs, and he is now playing the ostrich. The president is the president of the Republic of Ghana. There is a procedure, a machinery, on which people are appointed and disappointed or removed. The president receives petitions from the people of Ghana, decides to set up a committee to look into that as the mechanism, the lawful mechanism stipulated in our laws. And you are standing at your comfort zone, already making prejudicial, contemptuous commentary on the matter and saying that you are destroying a country. Who is destroying a country?
Well, his argument is with the composition of the Council of State, for instance.
Does it lie in his space to constitute that committee?
But he says
he doesn't have that power.
He says that council has become political.
He doesn't have that power.
Okay.
The man talking to you doesn't have the locus to determine or to advise how that, committee should be composed. That law resides under the preserve of the president of Ghana. Because he has not nominated Akufo-Addo to be part of the committee, you have a problem with it. Because he has not nominated Apenyo Markins, who is a loudmouth, to be part of that committee, we are destroying the democracy. This is the mentality of a group of people who believe that minus them, nothing should work. I'm very disappointed that a lawyer who is my brother is making these commentaries.
Okay.
These very fundamental, prejudicial comments.
Let me just bring him now. I mean, George, you heard what he said. He says that you're being prejudicial.
No, let me say this, please. My name is not George. My name is John.
John, I beg your pardon, John.
And next time you want to pair me with anybody to discuss issues, I prefer that we bring people who speak to the issue. Why do you call the minority leader loud mouth and all of that shouting? Look, madam, please, I'm not here to shout. I'm here because we talk about the petition to remove the CJ. And I believe that I reserve the right to state my opinion. And my opinion is very clear. I've stated that what we've done is...
You see, we have to have sound arguments within the context of respecting one another. When you say somebody is a loudmouth, it's not an insult. The reality is that the minority leader, including yourself, as far as Parliament is concerned, you've been loudmouth in the last few days. You bastardize and attack everything. And so you make a commentary look as if I'm not fit to debate with you.
John, let me just take your reaction briefly.
Okay,
John.
All right. So I believe that we need to look at it. Actually, I made the point. We need to make sure that the way we are politicizing our Council of State, we refrain from that. And I told you that the framework of the Constitution, we're expecting a very impartial Council of State, which will be able to look at the petitions such as this from a very neutral, professional point of view. But I'm afraid that what has happened in the last few years, especially this last election, the way we've thought about this, on that political line, it's made the Council of State, as it's currently composed, very partisan. And I'm worried that when we receive this petition, they are not going to be as neutral as the law requires them to be. And look, I believe that the president should have even rejected this petition, because we cannot be doing this to ourselves as a nation. When we continue to do this, what we are doing is that we are eroding the confidence we have in the judiciary. Look, I always say that the judiciary is the last bastion of our democracy. When it comes to the executive, a lot of issues. When it comes to the legislature, we have a lot of issues. Right now, what we have left that will settle disputes between these arms of government, that will settle disputes between people in this country, is the judiciary. And so this attempt to remove the CJ, for me, is very worrisome attempt. And well-meaning Ghanaian civil society organizations, religious leaders must fight against it. Let's maintain the decent and decorous judiciary we have. Because you see, my worry, my dear, is that when this example is set, future government may want to do that. And I'm sorry, it won't be good for our country.
Absolutely. Thank you very much for speaking to us. That was John Darko, the Member of Parliament for Swame. Still staying on legal-related issues this evening, the breach of the 48-hour detention by a rule of law by the state in the case of the former Director General of the National Signals Bureau, Kwabena Idu-Boahene, and his wife, Angela Boateng, has led to widespread criticism among a section of the populace. The duo has been in custody since last week following their roles in the diversion of $7 million meant for a cybersecurity project. Now, lawyer for the accused, Samuel Atachia, has also waded into that discussion and slammed at the Attorney General for engaging in media persecution rather than forensic prosecution. Speaking to sister station GH1 TV, he questioned the manner in which his client was arrested.
In the court of law, equity and good conscience, a man is presumed innocent until proven otherwise. That is why my client should be admitted to bail, not on the onerous terms of the captors, Yoko and the Attorney General, but in the court of competent jurisdiction, where the security to ensure that you appear before Yoko for the interrogation to continue will be reasonable. Because you see, if the conditions for your bail are unreasonable, it is a ruse to have you, detain them all. So you can go to the police station and they say that, okay, what are you going to use as security that you come for us to continue with the investigation? I want your house. I said, no, I don't want this house. I want the one in London. And they can play with this matter, and that by the time you say, Jack, you've been in cells for a long time. It's arbitrary and it's unreasonable.
That was counsel for the suspect, Kwabena Duboahin, Samuel Latachia. But let's go over the phone lines and have a conversation now, because we have Professor Kwejo Apieje Ichia. He's a law professor at the University of Ghana. Prof, thank you very much for your time this evening. Now, first off, by way of education, what is Ghana's legal provision regarding the detention of suspects beyond 48 hours without charge?
Well, the law, that position is clearly spelled out in the Constitution, that every person has a right to a bail. And so a bail is granted to a suspect, somebody who is alleged to have committed an offense, and the person may not have been charged, but they need to do investigations to be able to get the necessary evidence to determine whether the person should be charged and for what offense the person should be charged. And so because they need more time to do it, it is against the right of the person suspected to have committed an offense to languish in jail, because this would involve a violation of his right to freedom of movement and right to privacy and so on.
Prof, in this particular case, are we seeing potential human rights implications of detaining him and his wife beyond the 48-hour period? Hello, Prof. Unfortunately, we cannot continue that conversation because the phone lines have been a bit jerky, but I still have Mustafa Gbandi in the studios with me. You have had issues with the fact that people say the arrest or detention is inappropriate.
For me, I think that is neither here nor there. Because first of all, persons who are commenting on the matter itself are politicians. So they are the ones politicizing the matter. Number two.
But I mean, in this context, it's not even about the politicization of the issue. They say that he's been held for 48 hours.
Unfortunately, I just feel sad.
Okay, let me hold you on. I have Prof back on the line. Prof, I hope you can hear me now.
Yes.
Fantastic. So I was asking that in this particular case, do we see any potential human rights breaches?
Well, first of all, when the law would want to protect the rights of the citizenry, that is why, and it says that within 48 hours, we should let the person go on condition that the person has not been completely discharged from the case, but when investigations are completed and the appropriate charges have been properly identified by the police, then the person will be charged and then the person will go to court. So within the 48 hours, the person should get a bail. But if that is not possible, or if based on the nature of the case, the prosecution feels that the person should be detained for a longer period, then they will go to court and ask the court to extend that period. Now, in this case of Mr. Duboahin, I think that the Attorney General within the 48 hours decided to grant bail to Mr. Duboahin. But when you grant a bail, it is subject to certain conditions. Every bail is different from one suspect to the other. That is what the decision of the Supreme Court in the Martin Kpebu case, because they had prevented certain crimes from being granted bail, or people suspected of having committed those crimes from being granted bail. But the court said you have to look at each case on a case-by-case basis.
Okay, so but Prof, sorry, not to cut you, but the issue here has been with the fact that after he was granted bail, he was rearrested, and now his lawyers are saying that the bail conditions are so burdensome that they're unable to meet up.
Yes. So what's your question, please?
I'm just saying that is it appropriate that after 48 hours of granting somebody bail, you rearrest him?
It is possible. It depends on the information that they have come across or the evidence they have accessed, which indicates that the person, it is not appropriate or it's not in the interest of justice for the person to go free, and therefore the person can be arrested. That is within the powers granted the Attorney General. But again, there has to be justification for it. That is why I said earlier that the case has to be looked at on a case-by-case basis. And so based on the evidence or the information they have gathered, that may have led them to that conclusion. And it's allowed. The laws allow that.
Right. Now, the counsel for the suspect, that is Atachia, claims that he was not allowed to properly interrogate his client. He's actually accusing authorities of violating their legal rights during the detention process because he says that every conversation he wants to have with his clients tends to be recorded.
Well, that may lead to some violation of the rights of the accused person, because the accused person is entitled to have access to his lawyer or her lawyer and to have confidential communication with the accused between him and the lawyer.
So what are the remedies available? We understand that the case will be heard on Friday. The case for the bail application will be heard on Friday. What are the remedies for him?
I'm not privy to that, and I don't know specifically what they are going to ask for. So it's a bit difficult for me to give an answer to that.
All right. Prof, thank you very much for speaking to us. That was Professor Kwejo Appiah-Tia. He's a professor of law at the University of Ghana. Mustafa Gbandi, I don't know if you were paying attention to him, if you want to give a reaction.
Professor is my lecturer in security, and so I surely would admit to what he has said, except to say that I disagree on few issues.
Okay.
It's unfortunate that the detention involves a woman who has children. But under the circumstances where it is being suspected that a husband opens a company with a wife, and that company happens to have engaged in certain transactions that has a brush with the law, I mean, certainly if there's a need to arrest suspects, you cannot leave the woman out. And so when we make it look as if arresting a wife and a husband is without merit and without justifiable reasons, it's wrong, because there's some element of a collusion, some element of coming together to open a company. They may have opened the company for good reasons, but as we stand, the evidence available suggests that the company was involved in certain transactions that offends our laws. Anyone whose liberty have been seized, either by way of conviction or by way of arrest for investigation, is held to be, innocent until proven guilty. I am saying that instead of people politicizing the matter, we should rather look at the substance of the issues. Is it not within the right of the investigative bodies to arrest a person, and that such a person can be released and re-arrested? There's no illegality here. And if you are bailed and you haven't been able to meet the bail condition, you don't then bastardize the investigating institution and say that it is wrong or he's not justified. It is for you to go to court and seek for a review of the bail condition. That is what the court does. So I don't see why the MPP is all over the place running from the substance of the issue. Somebody allegedly have taken over $7 million of the taxpayers' money, ordinary people's money. You are not talking about that. You are rather circumventing and running away around illegalities. You talked about his lawyer's conversation being recorded, and that my lecturer believes that it violates their privacy. I think particularly when the people are still under investigation.
Conversations have to be recorded.
Of course, I mean, if a lawyer engages with him and outside there, investigative bodies are still investigating to unravel a lot of hidden issues, then of course you understand that the investigators need to monitor what is being discussed so that that conversation doesn't lead to some sort of concealment of relevant information or things that are primary to the investigation that is ongoing. So completely, it's unfortunate, but we have to face the law.
Okay.
It is our laws, and we have to go by it.
But are we not abusing the whole system of arresting and re-arresting him, considering the fact that he has been in custody for more than 48 hours?
It
In
doesn't
fact,
make him guilty.
on Monday, when the Deputy Attorney General spoke, he had indicated that they had been granted bail and were waiting to get their bail conditions right. Shortly after, he was re-arrested. Are we not abusing the whole process?
It is lawful that...
Especially because his counsel also says that the bail conditions are way too burdensome.
It is lawful that when investigations are ongoing and you are arrested and granted a bail and certain important matters comes up, you could also be arrested. So, for example, you commit, you steal, and you have been arrested, and then a bail is being granted, and some other crimes comes up. You should not be left to go because you've been granted a bail. You should surely be arrested for the subsequent crimes that have come up. The question is it unlawful? It is very lawful. It is within our laws to arrest and re-arrest. And so for me, we are just in an unfortunate but necessary situation that people must go through because really they did it voluntarily. They took the actions. They knew the consequences thereof. Persons who so far have been arrested, some of them knew that they were going to be arrested. Some actually made contacts with certain individuals to try and see how they can be protected.
Okay.
And so I don't see why my friends on the other side think that, we should, surprisingly or suddenly say that we are throwing away Act 29 or Act 30 because NDC is in power and because His Excellency John Dramani Mahama is in power. So the same set of laws we applied 8 years ago, we should change the standards, we should change the formula, we should change the way it is being applied because of the individuals involved. It cannot change.
Okay, let me just hold you on, and we can listen to the New Patriotic Party, who has dared the Attorney General and the Minister of Justice, Dr. Dominic Ayeni, to seek legal redress against former appointees accused of corruption than seeking public sympathy from the media. Here is the Director of Communications of the NPP, Richard Ehiagba, addressing the media a while ago.
This is an irregular act. This is not how the fight against corruption has been carried on as far as this Fourth Republic is concerned. Many of you are aware that the Akufo-Addo Bawumia administration prosecuted some of the NDC people and jailed them. But those actions leading to their persecution and holding them accountable was not a media activity. This is one of the key things we think that we need to bring to your attention because it is a deliberate act that a government is undertaking because it feels that perhaps it didn't have enough evidence or the evidence it has against these individuals that it claim have conducted acts of corruption, that either the evidence they know cannot stand the test of scrutiny in the courtroom, or they simply are engaged in a political persecution to vilify individuals and create disaffection for the New Patriotic Party. And so the question we ask, ladies and gentlemen, is why the Attorney General is not going to court, but rather going to the media.
That was the Director of Communications for the New Patriotic Party, Richard Ehiagba. Let me just take a quick reaction on the back of that.
Well, I think that it suffices to say that I would have thought that the MPP will reflect deeper into their activities in the last few years and also appreciate to take responsibility of the things they have done, and that we should all pray that individuals who they claim are being persecuted so far will go to the court and the court will exonerate them. But at least investigative body has a responsibility that when they have established that some wrong have been committed within the framework of investigation, persons who are involved ought to be arrested, they ought to be investigated properly and charged and put before court.
Okay.
And when that is ongoing, in today's democracy, the people of Ghana, one call they have made is for government to ensure that they bring people who are suspected to have done something wrong to book. There's a need for an attorney general to brief and update the public on what is going on. If that attorney general comes and actually holds higher the presumptive innocence of the accused in public and says that beyond that, these are the facts we have gathered so far, it shouldn't warrant a press conference. Look, these colleagues there are lazy, obviously not taking responsibility. They don't even realize that they are in opposition. And so because Nanado is not a president, they must make noise and make noise and make noise and talk about everything. But let me tell them, if Richard Anyahoba tomorrow, an issue comes up that he's been involved in some criminal activities, they can organize 1,000 press conferences. He will be arrested and he will be investigated.
Okay.
No amount of noise should subvert, seek to pervert and prevent lawful investigations in this country. It won't happen.
But wouldn't you rather go to court with your facts or your evidence instead of coming to the media to tell them what is happening? Wouldn't you rather go to court?
When they went to Kenufurata's house and didn't brief the media, all of you were asking questions. When they went to Addison's house and the facts were not out, questions were being asked until you got to know that Addison was spying on Bank of Ghana. And so if this time the Attorney General decides to come and brief the public.
Allegedly spying on the Bank of Ghana.
Well, he was spying on the Bank of Ghana. So if the same Attorney General comes out to brief the public and the journalists to appreciate the facts, how does that amount to persecution? And how does that amount to trying somebody in court? And other people are saying that the Attorney General is himself a lawyer, he himself a judge, and himself a prosecutor. That is an uninformed position. A position that carries malice with every attempt to protect and shield persons who ought and have been put under lawful investigation, and persons who the public suspect and believe that they have committed some wrongs. That is what they are trying to do, and it won't wash. With this government, everyone would have an equal right, and your right should be protected. You should also know that you do not have the right to take what belongs to another, and that if you do, there's nothing that can shield you from going through the process of investigation.
Okay. Thank you very much for speaking to us. That was Mustafa Gbande. He is the deputy, that position at the presidency, Deputy General Secretary of the party, of the NDC, and also Deputy Director of Operations at the presidency. Thank you very much for speaking to us.
Starr Today, first, fast, and credible.
You're still listening to Starr Today. Up next on the broadcast is sports. I've been joined by the head of the EIB Sports, Joel Champa. Joel, it's been a while. And what's it with this ball?
Oh, this rugby. I'm not sure if you heard the rugby ball before.
I don't think so. It will be my first.
Yeah, that's rugby.
Okay. So what's happening with rugby?
All right. So they're actually having a program. They're having a program to sort of catch them young with schools.
Okay.
So there's a school
initiating young people into rugby.
Exactly.
That's exciting because rarely would you see schools training on rugby.
Exactly. You know, lately because of what the president also mentioned, that there's going to be a school sports authority that will be, initiated soon. We're just seeing a few of the schools now. Getting into the various disciplines, not just football. You know, athletics is the intercore and what have you. And so, rugby is also trying to make inroads. They're going to have a few competitions with schools just to whip up the interest of the sports. This is, rugby is to UK or to the British, and American football is to the Americans. The balls are they look similar though.
But what's happening with Group I? Because yesterday I saw the scoreline between Comoros and Chad.
Yeah, so currently the group is changed, not for Ghana though, because we are still topping.
Okay.
It's Comoros who is now second place.
Not Madagascar.
No, it's no longer Madagascar.
Okay.
It's Comoros. They are placed second because they won their game. Virtually, Chad are the whipping boys. That's why you get people talking about the fact that Ghana going to face Chad. Obviously,
it wasn't a big deal
though. So they lost their game yesterday. And interestingly, in the World Cup qualifier also, when you look out in Europe, not in Europe, but then in South America, it was a nightmare for Brazil. world powerhouse football nation. They lost to Argentina by 4-1.
Okay.
Yes, and so that's the big news there. But then let's start from Ghana.
Okay.
Then we can quickly, listeners know what is happening. It's been banned here, banned there, banned everywhere. After Omina Sharks did face Sweden All Blacks in that particular Division 1 game, they are now facing certain bans that has been served by the Ghana Football Association. Remember, we've been speaking about hooliganism and why it needs to be curbed. What is being done to ensure that they gouge it from the various league centers. So the GFA the Disciplinary Committee of the FA, they've banned 5 Elmina Sharks officials for the rest of the 2024-2025 season, and they've been fined 10,000 Ghana cedis each. So their names are George Redu, Seth Armstrong, Kelvin Abuaji, Joshua Kibaza, and Kingsley Arthur. They have been fined. And also,
what about the founder?
Papa Kwesi Num has also been fined 10,000 Ghana cedis.
For what role does he play exactly?
So they're saying that he influenced. So he was seen to have gone on social media to incite hostility. That led to the mere misunderstanding at the stadium. He said he left the scene, but before he left the scene, he went on social media to type as to what really was going on, which was the negative. It wasn't the right news he typed there, and then that's what sparked up the misunderstanding between them. So he's also been fined 10,000 Ghana cedis, and he's been warned not to, else, they might increase that.
The fine.
It might even end up in a ban. So from watching most of the league games that his side will be playing. Yeah, so that's for the bans and the GFA giving a few of the people miscreants, if you want to put it that way. And also in Ghana, the Ghana Olympic Committee president, Benunu Mensah, says he will not stand for the upcoming GOC presidency. He served 8 years, so he feels it's just the right time for him to say it's okay. And I wasn't expecting him anyway to come say he's going to stand for the 3rd term.
But what about kids?
No, this Ghana Olympic Committee.
Yeah, I'm talking about the GFE. What about kids?
Why? You want kids to do it?
I can't say it on radio, but...
No, really kids. Anyway, so we'll make time and talk about Ghana football.
We have to talk about him.
Him
especially.
Currently, I would say they're doing a few right things, which we need to be talking about. So we'll make time.
But are those right things memorable enough to erase all the wrong things?
It's because those right things are not being well communicated to the public by some in the media space, by their own office, if I should say. You understand? They need there should be a right PR campaign to let people know that, okay, this is what we're doing. This is what the impact has been.
Right.
We can measure it. These were our KPIs. This is what we gave to XYZ persons to do. They've been able to give us results and what have you. You get it. So I feel they should do the right thing. We can also only propagate what they are doing. But if they're not doing the right thing, we're also going to talk about it to ensure that the checks are really ticked. The boxes are ticked well, and then we are ticking the right boxes anyway. Yeah. So that's what's happening
for sports
for Ghana. But on the African continent, we hear that Ivory Coast have announced they are withdrawing from hosting the AFCON Under-20, which just starts next month. Can you imagine? That's what
that's a very short notice. What happened?
So this is coming from their government. It's not the Ivory Coast FA who is saying they can't host the AFCON Under-20. It's the government who is saying that. So I don't know what. So
those of us who plan to go and watch the game in Ivory Coast.
Initially, it was even supposed to be in South Africa. I don't know what happened, and they brought it to Ivory Coast. And now Ivory Coast says they can't host it.
So in the interim, what happens?
So CAF has to. They have less than 24 hours to ensure that they get a new, host nation. And Ivory Coast, Ghana is close by. But I don't know which of our stadia is qualified enough to even host under-20 tournament.
No. It's probably South Africa.
We should go back to South Africa.
Yeah, we should.
People have planned for West Africa. You want to take them back to South. Yeah. So yeah, and there's something good CAF is coming up with. Aside this, CAF needs to make sure that they get a quick new host.
Okay.
But then there's something good for those who are young journalists who are interested in sports. There's this Future Voices of African Football that CAF is coming up with. And so it's for young people who are within the ages of let's say 20 to 25 years old,
oh,
who, are passionate about telling African football stories. And so what you need to do is, if you need to register and then send your cover letter, your resume, and an article in audio or in writing to this. It's the young reporter at cafonline.com. That's if you are interested. And when you are shortlisted, there's going to be a young reporters workshop in Accra, because there's going to be a tournament here in Accra being hosted by CAF. So Ghana is going to be hot, when it comes to football, hopefully next month. So that's what is happening. And for your information, let me just bust your bubble. If you had to be your club, that is Kotoko, you support Kotoko, right?
I do.
Yeah. Maybe your club would be enjoying $9.55 million if we were supposed to have been part of the FIFA Club World Cup. There's no Ghanaian club in there, so it's unfortunate.
Oh, I saw a few Saudi clubs.
These are the clubs who are going to be enjoying it. And again, they seem to be the people who are investing in their football for some time now. The likes of Tunisia, the likes of Morocco, the likes of Egypt. Al Ahly is there for Egypt. We've got Esperance de Tunis for Tunisia. And then we've got Sundowns for South Africa, because their league is also good. Well patronized and being spoken of and well marketed. And then you got Wydad of Morocco. So these are the clubs who are going to be enjoying $9.55 million each for just appearing at the FIFA Club World Cup.
And our local members are being fined left, right, center for hooliganism.
Yes.
Anyway, thank you very much, Joel. That's Joel Champong with sports there. But away from that, Accra Brewery PLC, producers of club beer, Metamalt, among others, has marked the 2025 World Water Day with a clarion call to all Ghanaians to endeavor to practice sufficiency in water usage. Now, this call aligns with the annual United Nations Observance Day, established in 1993, which highlights the importance of fresh water and raises awareness about the 2.2 billion people worldwide without access to safe water. My colleague Calvin Powell reports.
Established in 1931, Accra Brewery PLC has consistently reduced its water usage through innovative means, achieving a notable improvement in its operations over the past year. This enhancement resulted in the company's water use efficiency increasing by approximately 15%, with the aim of reaching net zero by 2040. Here is the head of Legal and Corporate Affairs, Solomon Eya, highlighting the company's drive for water sufficiency.
What we are celebrating globally as World Water Day. And as you may be aware, Accra Brewery as a business uses a lot of water in what we do. Water is an essential part of our production. Without water, we don't have a business. And as it is said severally this morning, water is part of our key ingredient, it's form about 90% of what we do. So this morning's event is to drum home our water efficiency initiative as a business and our contribution towards water efficiency.
Solomon emphasized the need for all humans to be conscious of the environment, particularly water, as human activities threaten sustainability.
Our inspiration is drawn from the fact that water is becoming a very scarce resource. And as you may be aware, water is a human right for everybody. And so it's a responsibility for all of us as businesses, as communities, as individuals, to ensure that the scarce resource that we have, number one, we use it efficiently, and for us as a business, we use it effectively so that the resource remains with us as long as our business also remains.
The event, held at the company's head office, was attended by stakeholders, including government officials, local media, strategic suppliers, and non-governmental organizations.
That is how we draw the curtain on this evening's bulletin. Thank you very much for your time. For more news updates, kindly visit starfm.com.gh. I am Tutua Danso. This bulletin was produced by Eko Anan, Benjamin Saki, Prince Essien, and Edem Kojo. Thank you very much. We are back tomorrow with more news contents for you. Have a good evening.